All right, are there any matters we need to address before we call on the defense?
Other, you mean motions, Your Honor?
Yes, sir.
We would, again, make a motion for directed verdict in this case on a couple of grounds, Your Honor.
All right, I'll hear from you.
First, we would renew the motion we had filed earlier, whereby spoliation of evidence was the issue. At the time we made the motion, the court recognized that we did not know for certain concerning the diaper and what was contained in it and those type things. But since then, the state's presented their case. Their own expert, Dr. Busman, has said with certainty that he believes that the diaper contained blood, and with certainty that the test can easily be run, and potentially that it could be caused by some type of abuse. Not necessarily that it was, but it could be. And all of those things were things we needed to be able to test and be able to bring to court and try to prove, but we were denied the chance to do so other than just testimony from Dr. Busman. That was a GBI agent that testified, supposed expert concerning gathering of evidence and working crime scenes. That, quite frankly, I believe perjured himself by saying he did not believe that there was any type of blood test that existed for fecal matter, and he had never heard of it, and that the diaper did not appear that it had any blood in it, all of which are astounding in themselves that he made those statements. So first of all, we would ask from the spoliation motion that this case be directed a verdict in our favor, notwithstanding any verdict that a jury might wish to grant here because of that. And then secondly, we'd have a second motion if you want me to go through that, Your Honor, if you want us to go one at a time. I'm not sure which way you want to handle it.
I'd let you go ahead and address all of your motions.
The second thing is the crime technician himself, when I asked him directly, did he gather any evidence at all, anything from the crime scene that could be used as evidence, and his response was no. And then the only evidence otherwise to say that came from that area would be a receipt that was testified to a moment ago that would establish that someone was at Walmart at a certain time. There's been much evidence presented in this case about injury to a child and about blunt force injury. But we've had the lead investigating agent for the state admitting they do not know in what way that was inflicted, not in any way. They can't testify to it in any way, shape, form, or fashion. So they have no evidence about what caused it. They have no evidence about where it happened. What they have is a large bit of suspicion, which I had said in opening in a way of that same way. This case has much suspicion and very little evidence. They've got a lot of what they suspect happened, but they had no evidence other than injuries testified to by experts, and those experts freely admitting they have no idea who did that. And then at best you have competing people that might be considered to be possible suspects, and maybe more than two, depending on how you look at it. The state cannot have met their burden beyond a reasonable doubt in this case, and we would ask that the court rule in favor of the defendant not guilty.
All right, Mr. Lamb.
With respect to the renewal of the spoliation motion, first of all, under any circumstances, I don't think there's any legal authority that would support the granting of a directed verdict based on that motion. Second, Busman didn't say with certainty that the diaper contained blood. Busman said that he looked up at the picture on the computer screen. He said, "Yeah, that looks like it could have blood. It could have blood in it. It's got a little bit of a reddish tint or something like that." Later, however, Busman said, "Well, it could be red dye. Don't know what the child ate or something." It also is, with all due respect, and I think Dr. Busman is a fine doctor. Heck, he's my doctor, and I think he did a great job of dealing with with the issues in this case. With dealing with the issues in this child's medical treatment and all of that. Okay, but neither he nor really anyone else is qualified to look at a photograph and say that item contains blood. I mean, from looking at a photograph, there's no way to do that. And to ask him, does it look like it's got blood in it? Yeah, it looks like it's got blood in it. It's red, it's reddish or whatever. He's looking at a photograph. He's not looking at a diaper. The person who looked at the diaper, okay, who is qualified and highly experienced in examining crime scenes and, making determinations about blood, observing things that appear to be blood, doing tests, presumptive tests, field tests, as it were, for blood and so forth, said, I looked at it. If I thought that there was anything that looked like blood in it, then yes, I would have taken it. But it was just a dirty diaper. It didn't look red when you were looking at it with your naked eye, because these photographs were taken at night under a flash, and who knows what distortion that induces. But in any event, he says, it doesn't look like it didn't look like it had blood in it, so I didn't collect it. He didn't perjure himself. He said that he wasn't aware of sending of anything that they would send to the crime lab to determine if there was blood in feces or something to that effect. He said he wasn't familiar with whatever this Hemocult or something, that test. Okay, Hemocult is a test that's used in a medical environment, in a medical setting. I don't know if they have Hemocult tests at the crime lab or not. What Gibson went on to say, though, was I have tests in my vehicle. I have tests like right there available to me. Anything I see that looks like blood, that I have a question about whether it possibly could be blood, then I can test it. And I've tested all sorts of things, even things that turned out not to have blood on them. I made the comment, I think, at one point in the trial to one witness or another, he'll tell, if you spill red Kool-Aid, they'll test it. But he didn't see anything that justified or warranted a test. And so he didn't collect the diaper. Finally, even if he had collected the diaper, and even if the diaper had blood in it, it wouldn't have any relevance to the outcome of this case, because there's nothing that would have been revealed, and all three medical doctors testified to this. There was nothing that would be revealed by a bloody diaper that would affect their opinions about the cause of death. The cause of death in this case was a tremendous impact, a massive blow, a massive head injury, and they said that's the cause of death. The kidney wasn't the cause of death. The bruises weren't the cause of death. A poopy diaper wasn't a cause of death. Furthermore, the medical examiner who got this body was preserved immediately upon death. Okay, so somewhere from 6, 8, 12 hours after that diaper was created, after that point, 6, 8, 10, 12 hours later, this body was the body of the decedent was preserved and sent to the crime lab. And Dr. Clark testified that he examined the intestines, and there was no injury. There was no blood. He examined the colon. There was no injury. There was no blood. He examined the GI tract, essentially from top to bottom, and there was no blood. So what about the blood internally? Couldn't that seep into the intestines? I don't remember if Busman was asked this question, but Olick was asked this question, and Clark was asked this question, and they both said there's no way. There's no anatomical pathway for the blood around the liver that's being collected. And if you look at that exhibit that was put into evidence, you'll see, the blood that there is a photograph of there is essentially, it is essentially sealed in one of the compartments of the body. I can't remember whatever the cavity was called. I can't remember what it was. But it doesn't get to the intestines. It wouldn't come out in a bowel movement at any point. So even if we should be able to test the diaper, there's no reason to believe that testing the diaper would have accomplished anything. It wouldn't have changed the outcome, and there's no reason to believe that it would have been confirmed that there was blood. The child was eating, they said was eating barbecue Fritos. You know, if he's eating barbecue Fritos, well, you know, sometimes that may make the bowel movement red too. But there's nothing that connects that diaper to this case, to the injuries in this case, or to the other evidence in the case.
All right. Address the directed verdict motion.
I'm not aware of any case that's ever been decided in the state of Georgia that says that you must have evidence from a crime scene. I'm not aware of any case that's ever been decided in the state of Georgia that says you must have specific evidence of an instrument or the means by which blunt force trauma was affected upon someone. And the reason that that's not necessary to have is because there are so many things that you simply can't account for them. What the testimony was in this case was that if Dr. Clark, I think, exhibited it or demonstrated, he said, if you took somebody took an infant, a child by the shoulders like this, and you know, slammed them down on a hard surface, and he used, I think he said, the floor, a desk, a chair. He may have said the wall, but if you took someone and you slammed their body down like that, a lightweight child, and you slam their body down like that with enough force that would be enough force to cause the injuries. That would be the type of trauma that could cause the injuries. To say if you can't specify which particular item was used to inflict the trauma, to say that means that a defendant is entitled to a pass, that she's entitled to walk because we don't know whether she slammed that child's head against the bed frame or against the desk or against the chair or down on the floor. I mean, to say that is to say, look, if you just make a little effort to not let the weapon be found, then murder's free in Georgia. I mean, frankly, I think it's an absurd argument. The evidence here is sufficient for a jury to make the determination of the following things: that this child received injuries during a specific time frame, a time frame that extended no more than 30 to 60 minutes from the time he presented at the hospital. Maybe less, but no more than 30 to 60 minutes. That the child received that trauma during that time frame. And during that time frame, the evidence is sufficient for the jury to make the determination. I mean, I'll grant you it's an issue of fact, but it's always an issue of fact. That's why we have juries. But it is certainly sufficient for the jury to make the determination that there was only one person in the room that could have inflicted this trauma on the child. And if they believe that that child was healthy and okay when Jay Williams walked out of that room at 11:55 to go get pizza, if they believe that, and I submit to the court that there would be ample reason that they should believe that, but if they do, and when he comes back at 12:31, his baby is essentially brain dead and in literally a mortal countdown at that point. That it's just a matter of time. And the only person who was with the child and who had access to the child during that intervening time period was Trinity Poague, and the evidence is undisputed about that. Then that is ample evidence for the jury to find that she committed the offenses of cruelty to a child, that she committed the offense of aggravated battery, and that ultimately committed the offenses of felony murder and murder.
All right.
The motion should be denied.
I do think that the case, albeit primarily circumstantial and reliant on the testimony of Mr. Williams about the condition of the child when he left, and then the medical witnesses about the potential timing of the injuries, is sufficient to create a jury question as to whether or not she's guilty of the offenses. There's plenty to argue about, but But I do think, depending on what the jury finds about those facts, that their verdict would be supported. So I'm going to deny the motion for directed verdict. Nothing has changed in my mind about the spoliation. I primarily do not believe that there's indication that the officer acted in bad faith. I don't think it's clear that the evidence had exculpatory value. I think clearly exculpatory is the language that's used in some of the cases. I'm not even sure that it has potentially exculpatory evidence. If you listen to most of the medical testimony, it would indicate that it doesn't. There may be some openings there where some of the witnesses testified, that blood could be evidence of long-standing abuse or something of that nature. But I certainly don't think that these circumstances warrant dismissal based upon not securing that evidence. So I'm going to deny the motion to dismiss on spoliation. When we get back, the defendant is going to have the opportunity to present her case, and I do want to address a couple of things with the defendant concerning that. And so I'm speaking with you now, Ms. Poague. One of the many rights that you have with regard to a trial when you're the defendant is the right to testify. Are you aware of that?
Yes, sir.
Okay. And you have the right to testify if you choose to. I assume you're aware of that.
Yes, sir.
You also have the right to remain silent, and if you remain silent, your silence could not be held against you. Have you been advised that by Mr. Gamble?
Yes, sir.
Okay. And have you and he had time to discuss that?
Yes, sir.
All right. I want you to understand that is your decision. Obviously, the reason you have a lawyer is to consult with the lawyer and consider his opinion, correct?
Yes, sir.
But ultimately, you have that right. You understand that?
Yes, sir.
And so you will have to make that decision. I'm not going to ask you what that decision is, but I want you to understand that it is your decision. Do you understand that?
Yes, sir.
Do you need more time to discuss with Mr. Gamble that decision?
No, sir.
Okay. All right. Well, when we come back, it'll be the defendant's case, and we'll hear whatever witnesses, including potentially Ms. Poague, but if not, and if your lawyer requests it, I'll give an instruction, about the legal effect of your not testifying. Do you understand that?
Yes, sir.
Okay. All right. Is there any other matter that we need to address before we return?
Not that I'm aware of yet, Judge.
No, Your Honor.
All right. I don't want to get too far into your strategy and all, but do you have an estimate of how long the defendant's case in chief will take at this time?
It does.
Didn't want to share?
Well, I can some way. It does depend on a couple of decisions that have to be made.
Right.
I'm certain that it would be through by Friday for sure.
Okay.
That much I am positive.
When you say by Friday, by the end of the day Friday?
Yes,
I'm just trying to.
yes,
Okay.
yes.
Okay.
I'm sure. I feel certain of that part.
Okay.
And it may be quicker than that.
Okay.
I do have an array of witnesses that aren't particularly long.
Okay.
I don't know how long that ends up. Sometimes you think it's 10
Okay.
minutes and it's an hour,
All
but
But we're not likely to find ourselves at 2 o'clock ready for closing statements. Is
today.
that right?
I don't think so, yeah.
Okay. All
No.
right. All right. Well, we'll address that if it happens, I suppose. But at some point, have y'all shared the jury instructions? Oh, you have? Okay. So I'll be studying that, and at some point we'll have a jury charge, kind of depending on how things go the rest of the day. Okay. All right. We'll be back at 1:10.
Thank you.